Well, welcome to today's Brodie's webinar, Group Proceedings, a Game Changer for Sports. My name is Craig Watt. I'm a solicitor advocate within the Advocacy by Brodie set. I sit within the business disputes team, resolving commercial disputes for small, medium and large organisations across the globe. I'm joined by my colleagues, Laura McMillan, Carly Forrest and Andy Nolan. Laura is also a solicitor advocate within the Advocacy by Brodie set. She's a partner within our insurance and risk team, specialising in health and safety, claims defence and insurance issues. Carly is also a partner in our insurance and risk team, specialising in catastrophic injury claims involving head and brain injuries, severe spinal conditions, amputations, as well as psychiatric and psychological disorders. Finally, I'm joined by Andy, who is a partner heading up our sports practice, and he specialises in commercial contracts. So what are we here to discuss? Well, we tend to consider whether or not the new group proceedings procedure in Scotland is likely to be a game changer for sport. The stimulus for today's webinar was not only the new group procedure in Scotland, but the announcement in December of last year that a number of rugby players intend to bring collective proceedings against World Rugby, the RFU and the Welsh Rugby Union. The basis for the claim is for failing to provide them with sufficient protection from the risk caused by concussion. Now, since then, it was announced just only last week, at the tail end of last week, that around 40 former rugby league players intend to bring similar proceedings against the RFL. Now, at present, the current actions are only intended to be raised against the respective sports governing bodies, but it's possible that claims may also be directed against others at the various levels of these sports, for example, tournament league organisers, clubs or schools. Now, these threatened group proceedings, alongside an increasing awareness of the medical science around concussion, could be a game changer for sport. I'm reminded of the possibly apocryphal tale from not so long ago, where a Partick Thistle trainer was noting that the striker didn't know who he was after suffering a head knock. And John Lambie, the manager, famously replied, "Great, tell him he's Pelé and get him back on." Now, that's not so long ago, but it's a world away. So what are we going to cover today? Well, I'm going to touch upon the impact of group proceedings on sport. I'm then going to hand over to Carly and Laura, who are going to touch upon courts may approach sports-related brain injury claims. And finally, passing over to Andy, who will touch upon the contractual chain in sport and the potential impact on contracts and the sport itself, or the sports themselves. So turning to the impact of group proceedings in sport. Well, what are group proceedings? Well, for the first time, groups of 2 or more people with the same, similar or related claims have a mechanism to raise proceedings together in a single action in the court of session. In Scotland, these class actions will be known as group proceedings. For some years, there's been pressure for class actions or group procedures to be allowed across the United Kingdom. The courts in England and Wales have had these procedures in place since about 1999, 2000. In practice, the courts in Scotland have been operating a workaround to allow separate actions to run in tandem with the consent of the parties and the cooperation of the court. For example, in the personal injury space, the vaginal mesh claims, where parties chose certain cases to advance as test cases, and then for all of the other remaining cases to be put on hold. This was a workaround. But it's fair to say that there's been a demand for a proper system for managing groups of cases, and we now have that in Scotland. The new court rules published on the 9th of July of last year and came into force on the 31st of July last year implement Part 4 of the Civil Litigation Expenses and Group Proceedings Scotland Act 2018. Group proceedings in Scotland will proceed on an opt-in basis. This means that potential class members must elect to join a class in order to participate. This is opposed to the US style of opt-out system, whereby those falling within a class definition are automatically included unless they elect to opt out. So this means that we're likely to hear more adverts on the radio and see more in the press from insurance firms trying to encourage potential claimants to join others by way of group proceedings. Permission to proceed by way of group proceedings is required to be granted by the courts, and the principal requirements are that it's a group of claims that must raise issues of fact or law which are the same as, similar, or related to each other. The court must also agree that there is a prima facie case, that proceeding as a group will be more efficient than as separate claims, and that there is a real prospect of success. So that's a very quick canter through group proceedings. What does this new legislation mean for sporting regulators, organisers, clubs and schools that play sport? Well, since the aim of the new rules is to make it easier for claims to be brought, it seems likely that we will see an increase in the number of cases proceeding before the Court of Session. Group proceedings should remove, or certainly lower, one of the barriers to pursuers bringing an action before the court themselves, that is, exposure to expense, either because their own solicitors, exposure to their own solicitors' expenses, or awards made against them. Now, this is because it's likely that there will be an agreement between pursuers and solicitors taking on these cases, that the solicitors will take or accept whatever they are awarded in the expenses if they are successful, and they will pick up the tab if they lose. Now, what's in it for the lawyers? Well, this exposure will no doubt be covered by insurance policies or litigation funders, and we expect that there's going to be a keen interest from third-party litigation funders for this new group proceeding structure. Litigation funders are more inclined to back pursuers with lower value claims in a group proceeding than they would if they were each acting alone. The theory is that the funder will be able to justify greater resource to pursuing the claims where the return is likely to be higher. So how quickly these group proceedings get underway is likely to be determined by the speed at which litigation funders, working in conjunction with the group of pursuers law firms, establish a presence in the Scottish litigation market. Accordingly, it's possible that we may see claims, including claims arising out of injuries occasioned whilst playing sport, which wouldn't previously have been individually litigated. These will now be brought under the group proceedings procedure in the Court of Session. Now, we haven't yet seen any group proceedings approved by the Court of Session yet. There are some applications being advanced. What we are seeing is it may not be entirely straightforward. It's open to the judge, for example, to refuse an application on quite a large number of grounds. And we envisage that defenders will challenge the applications for matters to proceed by way of group proceedings at the permission stage. The key takeaway from this is that group proceedings make it easier for claimants to unite, to share effort and resource to raise claims together. Now, that shouldn't mean that sporting bodies are going to face more large value claims. These would have been litigated over previously. But it does make it more likely that they will have greater exposure to court actions in respect of lower value claims, which can now be grouped together. So finally, how can sporting bodies, in its generalist term, be prepared? Well, firstly, and most importantly, they should check their insurance policies to ensure that they have coverage for claims that they may not have worried about previously, perhaps because the value would have been relatively low and they would have dealt with it informally. They should put their insurers on notice as soon as a claim comes in, and certainly engage with them proactively if group proceedings are threatened, so that they and the insurers can be ready when intimation of the group proceedings is made. That's because it's just as unfamiliar to the insurers at the moment as to the insured. If no insurance cover is in place, after the event insurance could be considered to minimise your exposure to expenses of group proceedings. Internally, you certainly want to consider how you're going to handle the group proceeding claim, who within the body will take the lead, who will be in the team, who will instruct solicitors, who will carry out the investigations, what is the reporting line, and who will liaise with your regulators, for example, on health and safety matters, or if you've got professional obligations. Group proceedings are new. They're going to attract press attention, particularly when it involves claims arising out of sporting arenas. So sporting bodies should consider who's going to deal with the PR fallout, what can be said to the press which will not damage their reputations, or indeed the defence when it comes to be stated in the court. I'm now going to pass over to Laura, who's going to talk about how group proceedings might come about and the initial hurdles that claimants and defenders might have to overcome.
Thanks, Craig. So group proceedings arising from sport-related injuries are most likely to be instigated by firms of solicitors who specialise in personal injury. So if I put myself momentarily in the shoes or maybe slippers of a claimant or pursuer personal injury solicitor, then I think in this context, the first and most obvious question to ask would be, is there a group of individuals who have claims with a common factual or legal issue to justify group proceedings? And it might be that the answer will present itself to me before I've even asked the question by a direct approach from a claimant or a group of claimants looking for legal advice, or it may be that I need to explore the answer to that question through research and marketing. And that research might involve looking to see what's happening in other jurisdictions, not only in the UK, but across the world. Obviously, claims for early onset dementia and CTE arising from head injuries are attracting a good deal of media attention at the moment, and we know there have been successful group actions on this subject in the US. We also know that court actions in the US have previously led to similar multi-party actions being brought in Scotland. For example, the pelvic mesh litigation that Craig's mentioned, but also the Celebrex cases and also the metal on metal hip ones too. And a quick Google search brings up a good number of Scottish claimant solicitors already offering assistance to those who think they may have suffered brain injuries from sporting activities. So if I was in the claimant sphere, the potential for group proceedings from sports injuries and in particular brain injuries would undoubtedly be something that I would be thinking about right now. But of course, brain injuries are not the only type of injury that sporting organisations might need to be aware of when it comes to group proceedings. Craig, as you alluded to, we may see group claims in Scotland for minor physical or psychological injuries, claims that might not have been litigated previously because of their minor nature. And I agree with what you said, Craig, that in the past there might not, for example, have existed an appetite by claimant solicitors to litigate for a single claim where compensation might not exceed, say, £1,000 or £2,000. And indeed, a sporting organisation or their insurer might have been inclined to settle such a claim before a court action was raised because of the potential costs of defending it. But if you've got, say, 50 or 100 such minor injury claims, then the picture might be quite different for both sides. There's more at stake, which creates more impetus to litigate and a greater likelihood of the claims being defended as well. So once a suitable group and a common issue or common issues have been identified, the next step would be to think about who is going to be sued. The courts won't have any difficulty with there being more than one defender in group proceedings, as long as there is a commonality and a stateable legal case against each defender. So by way of example, if the identified common issue was tackling in school rugby, there may be a number of schools and local authorities named as defenders in the group proceedings, as opposed to there being just one school and many claimants. Another example, the common issue that is identified might be allegations around lack of appropriate headgear in elite rugby. And in that case, the defenders might be the governing bodies, the clubs, the tournament organisers, and maybe also the manufacturers of the equipment itself. But normally, and this makes absolute sense, a claimant will sue the party or parties against whom they have the strongest case in law. But there's also another related point, and it's a key one, and for claimants, and that is knowing who has the means to pay. So rather than suing the coach, they're more likely to sue the club. Rather than suing the referee, they're more likely to sue the organiser. Rather than suing the teacher, they're more likely to sue the school or the local authority. And that means, again, as Craig's mentioned, that an organisation which finds themselves on the receiving end of a group claim will want to know the answer to the question, do we have adequate liability insurance? Or perhaps in cases where there is a long time between the alleged wrong and the injury arising, such as early onset dementia, the correct question would be, did we have adequate liability insurance, and can we put our hands on the policy? I have a bit of a cautionary tale, but I frequently had to deal with situations where a company or an organisation has had to meet the cost of often significant claims from their own pocket because they can't trace a policy of insurance, which they are quite certain that they've taken out. Nowadays, there's a database of employers' liability insurance policies, but it's not perfect, and there's no equivalent for public liability policies as yet. So keeping a record of your insurance policies and their start and end dates is a really simple step, I think, that might pay dividends for you in the future. And staying with long tail or historic claims, another initial hurdle for claimants might be time bar. And that's an issue which I've seen mentioned in the press in relation to the rugby claims. And I wanted to say a few things about that specifically in the Scottish context. Firstly, it's worth remembering that when it comes to the question of time bar for personal injury claims, in Scotland at the moment, the clock is normally a 3-year one, and it only starts ticking when an individual knows or ought to have known that they've suffered an injury as a result of an alleged wrong by another party. So, for example, the court may consider it reasonable for a claimant to say that although they were diagnosed with a traumatic brain injury 10 years ago, they only learned that it may have been caused by repeated knocks to the head when they were a child on the school rugby field when they discussed it with their doctor last year. In that instance, the court may find that the time bar clock only starts ticking from this later date, that being the date of knowledge. And for children, it's also worth remembering that even if their injury is an instant one, say a broken leg from kayaking, the 3-year clock only starts ticking when they turn 16 years of age. So finally, on time bar in Scottish personal injury claims, the courts have got a discretion to allow time-barred claims to proceed if it's considered just and equitable to do so. And that's something that we think could happen here in the context of group litigation for sporting injuries, particularly more serious ones. So whilst I think it's correct to say, and as identified in the press, that time bar might be an issue for brain injury claims, the position in Scotland may be less clear-cut than it is in other countries and other jurisdictions. So time bar aside, for long tail or historic claims where the injury manifests a long time after the incident or incidents complained of, it might be difficult for a claimant to prove the causal connection between the incidents and the injury. And that's something that Carly's going to cover in more detail. But for the defender, whoever that might be, this long period between the incident and the injury can also present difficulties when it comes to trying to successfully defend liability in a court action. And what I mean by that is when it comes to trying to resist the allegations of wrongdoing. So if a claimant says that they were repeatedly forced to stay on the rugby field after suffering knocks to the head, and the defender doesn't have any evidence to the contrary, then as long as the claimant comes across as credible, the claimant's witness testimony may well be sufficient on its own to establish liability against the defender. And this reflects what we often see in asbestos disease cases. And then add into the mix, it being in the context of group proceedings, a court's likely to be even more persuaded if claimant after claimant after claimant gives a similar story. So while in most personal injury claims, the onus is on the claimant or the pursuer, to give it its proper title, the onus is on them to prove their case. In historic claims, it can feel like the onus of proof effectively shifts to the defender to positively discredit what the claimant or the claimants are saying. And when that relates to something that happened 10, 20, 30 plus years ago, that might be pretty tricky. And again, asbestos disease claims serve as a real example of how difficult it can be to defend liability in this way. So if you're a business, an organisation, an establishment that thinks it might be exposed to long tail claims arising not just from sport, then my first tip on your defence strategy is to be proactive and to think, what can you do right now to collate and secure retain the evidence, including the insurance information that you might need in the future to defend those claims. And with that, I'm going to pass you over to Carly to talk a little bit more about defence strategies.
Thank you, Laura. Yes, so now I'm going to talk to you about what you should be thinking in terms of the defence to any claims which arise. But firstly, I think it's important to look at what actually needs to be established for a pursuer to succeed. So firstly, they have to show that he or she was owed a duty of care by the defender or defenders. Secondly, the duty of care was breached. And thirdly, the damage suffered was caused by that breach. So it's not difficult to see that in a sporting context, a pursuer will be able to establish that a duty of care was owed, and potentially by a number of parties. As Craig talked about, potentially other players, clubs, governing bodies, club doctors, teachers, schools, referees. There's a long list. And I think it's important to mention here that within that list, it's likely there will be situations where vicarious liability will apply. So for example, between a player and a club. And in the case down south, it was a Manchester United player who sued a player from Middlesbrough FC, and the court held that the club was vicariously liable and therefore responsible in law for the actions of their player who had committed a high tackle. Now, the claimant in that case was awarded 4.3 million in damages, presumably picked up by the club's insurers. And the same concept of vicarious liability will apply in terms of any employee-employer relationship or a master-servant relationship. So those the employer has control over. So that could potentially extend to coaches brought in by a school, even if they're not employees. And it's also worth noting here that employers and educators will have certain non-delegable duties of care. So we don't have time to look at the detail of that today, but that will be an important factor to consider when assessing liability in any claims which arise. So let's assume it's established that a duty of care exists. We then turn to consider whether or not that duty of care was breached, and that's going to depend on a number of factors. So in a civil claim, it's for the pursuer to prove his or her case on balance of probabilities. So was it more likely than not? It's a lower standard than the criminal standard of proof, which is beyond reasonable doubt. And as Laura touched upon, evidence gathering is likely to be more difficult on both sides of the fence the longer time has elapsed between the alleged negligence and the manifestation of any symptoms developing. So it is important that organisations think now about how best to risk manage and protect themselves going forward. So from a defence perspective, being able to evidence that foreseeable risks of injury have been considered and a risk assessment carried out to reduce the risk to the lowest level reasonably practicable is key to defending such actions. And most sports will have a governing body and guidance on rules and best practice. And if we look at rugby by way of example, the concussion policy introduced by Scottish Rugby is stated as being mandatory for anyone participating in the game in Scotland. So assuming clubs and other organisations are following that protocol, as well as the rules of the game, it could be difficult for a pursuer to establish there has been a breach. Now in 2015, the Scottish Government and Sport Scotland produced a single concussion policy for all sports. So that covered rugby, hockey, football, shinty, judo, netball. And that policy differentiates between rest and rehabilitation, which is going to differ for younger and for adult players. And that's on the basis that research suggests that young developing brains need slower rehabilitation. And that's the sort of thing that needs to be considered as part of a risk assessment, depending on the age of the players. We know that the football associations in England, Scotland, Ireland have recently imposed restrictions on school-aged children being allowed to head the ball. These restrictions need to be followed. That's something that has to be factored into risk assessments going forward for any organisation involved in children's football. And in other developments, the SFA in December welcomed an announcement from the International Football Association Board, and that approved trials of additional permanent concussion substitutes. So that means in the event of an actual or suspected concussion, the player should be permanently removed from the match, and that's actually being trialled in the Scottish Cup. So for the purposes of today's talk, let's assume that a breach of duty has been established. Is that the end of the line for any defence? Well, no. because causation is a crucial issue and that has to be considered in each and every case. And what do I mean by causation? Well, can a pursuer prove that the breach of duty caused the loss or the condition complained of? So for today's purposes, we're talking about early onset dementia and chronic traumatic encephalopathy, which for now on I'll just call CTE. And as we know, dementia sadly is not uncommon in the general population. And the risk factors include age, environment, lifestyle, health, and also whether we carry risk genes, making some of us more predisposed than others to suffering from the disease. Now, CTE is a progressive and fatal brain disease, and that is associated with repeated traumatic brain injuries. But the research in the condition is still at a relatively early stage in terms of the diagnosis, the cause, and the symptoms, and also the risk factors. So what evidence do we need to assess causation? Well, a full forensic history is absolutely critical to explore pre-accident potential head trauma, and that could be potentially undetected. It could be an innocuous sporting injury or from some other activity. Family history and lifestyle factors, they're also relevant. So as I say, genetically, was a pursuer more likely to suffer dementia in any event, regardless of their sporting career? Is there a strong family history of dementia in family members who don't play sport? So on balance of probabilities, is it likely to be genetic or is it likely to be caused by their sporting career? And gathering evidence to break the chain of causation, that's going to be factual evidence, as I've just mentioned, but also specialist medical evidence is going to be required. So that's likely to include things such as neuropsychological testing, neurological examination, brain imaging, and bringing the right experts on board at an early stage. There also needs to be a forensic analysis of the person's playing career, the position they played, the injuries suffered, where they recorded, are there contemporaneous medical records? In a football context, how likely was someone to have headed the ball on a regular basis? What type of ball was used? And we know that the type of football used has changed over the years from leather to synthetic materials, which don't hold so much water. And a couple of other points that I wanted to cover on the defence side is firstly the defence of valenti, which is a complete defence, and if that's established, it removes any liability at all. Now, the burden is on the defender to prove the pursuer voluntarily accepted or consented to the risk of harm, and to succeed it needs to be established that the pursuer knew and fully appreciated the risk of harm. So in one view, it might seem obvious that if you choose to play contact sport, there is a risk of being injured. But I suspect the counter argument will be, well, this isn't a single head injury or a broken leg. And for those players now being diagnosed as suffering from early onset dementia from repeated knocks to the head, the argument is likely to be, well, can it really be said that they voluntarily accepted or consented to that risk of harm? I think the science in this is only really starting to emerge now, or at least in the past few years. So we don't yet know how the courts are going to approach this particular issue. That said, the concussion protocol does clearly state that primary responsibility for health and well-being of the player lies with the individual player. So in agreeing to participate, players have to take seriously the risk of injury to themselves and others. And as I say, what the courts will make of that remains to be seen. I thought it was worthwhile just looking at some cases which are quite interesting. There's 2 Australian rugby cases from the early 2000s. And although they wouldn't be binding on the Scottish courts, it was interesting to look at the approach taken. Now, both claims failed. It was Agar against Hyde and Halen against New South Wales Rugby Union. And in Agar, the court refused to accept the governing body and members of that board had a duty of care to change the rules of the game to minimise injury to players. The High Court said that rugby was an inherently dangerous sport and they refused to recognise the duty of care. And in Halen, a player was rendered quadriplegic and sued the rugby union. And the injured player argued that as the union controlled the game, there was therefore a duty to ensure players weren't subjected to an unnecessary risk of injury. Now, the court held that the union did not have a legal obligation to ensure the player's safety, as again, he took part in the game of his own free will and was aware of the dangerous nature of the game. But if we contrast that with, there's an English case from 2003, Wills against Evans. And in this case, the claimant suffered a severe spinal injury when a scrum collapsed. Now, he didn't have the necessary expertise to play in the front row in a contested scrum, and the player sued the referee on the basis that the referee owed and had breached a duty of care by putting him into that position when someone else was sent off. The Court of Appeal found that referees, even at an amateur level, owed a duty of care to the players. They said that rugby is a dangerous sport and the rules are designed to minimise the risks, but it was for the referee to enforce the rules. And actually, in that case, it was the Welsh Rugby Union who were vicariously liable, as the referee was their employee. And what about contributed negligence? Well, what about a situation where the doctor says a player should not play on, but the player and potentially the club don't want to accept that advice? The player may have a financial incentive to ignore the advice or just want to play on regardless, but who has the final say? Now, the doctor should be independent from the club to help to avoid a situation where commercial pressure comes into it. And the general protocol advice is that a player should be removed from the field of play if there is a confirmed or suspected concussion. And I'm sure we've all heard the phrase of if in doubt, sit them out. Now, the protocol from Scottish Rugby actually states that failure to follow the policy will be regarded as an act of misconduct under their disciplinary rules. And they've set up a whistleblowing facility whereby a confidential referral can be made to the Rugby Union's Chief Medical Officer. But what about amateur and young players? Well, concussion protocols are generally based around red flags or symptoms that might indicate a concussion, but the test is a medical one, and at a professional level it's carried out by doctors. So does that duty of care extend to coaches, referees, clubs? How do they carry out an accurate assessment of concussion symptoms in the absence of a trained medical professional? Does that mean that a trained medical professional has to be on hand at all levels? And is that practical or achievable? Now, courts are going to have to consider all of this going forward, and the difficulty may be who is ultimately responsible for players' safety. Is it the governing body, the organiser, the club, the coach, the medic, the referee? It could be different depending on the level the sport's being played at and the qualifications and experience of the coach or referee. Are the guidelines issued by the governing body accurate? And if those are followed, can an organiser or a club be expected to be criticised if that's what they followed? Is it reasonably foreseeable that if they followed that guidance, they would fail to meet their duty to take reasonable care for those playing? I think it's worth saying we could potentially see the government legislating on the issue, and a concussion summit has been launched by the UK government. Although I understand that that focuses on ex-professional players, there have been calls to include concussions at youth and school level also, to consider removing the tackle from rugby in school settings. And just before I finish, I think it's worth acknowledging that contact sports are never going to be without risk, but no risk is not what the law requires. And in practical terms, we all know there are huge health benefits from participating in exercise, both non-professionally and professionally. And professional athletes overall have less risk of other health conditions. So it's all about balancing the benefits at the same time as trying to reduce the risk to the lowest level reasonably practical. And that's going to be a combined effort between all stakeholders involved in these types of sport. And with that, I will now hand over to Andy, who's going to discuss contracts and the operational impact in sport.
Thanks, Carly. Good afternoon, everyone. As Craig mentioned, I head up our sports practice and I specialise in commercial contracts. I'm going to speak about the contractual chain in sport and the potential impact of class actions on contracts and sport itself. I think we should start by thinking about the role contracts play in sport. Contractual relationships abound in the sports context. For example, in the context of private members clubs, there's a contractual relationship between individual members of the club. If an organisation is incorporated, the members have a contract with the organisation itself. In a professional context, there may be a contract of employment between players in a club, or indeed between coaches and other officials and the organisation itself. There will be a form of agreement between schools, parents, and other participants in sporting events. Across the sector, there are laws, rules, regulations, and protocols that organisers and participants, such as clubs, schools, players, and officials, agree to be bound. By way of example, participants involved in rugby agree to adhere to the laws of the game and the playing charter imposed by World Rugby. So in Scotland, participants agree to be bound to the rules stipulated by the SRU, including the SRU's concussion protocol. When a sporting organisation such as rugby, cricket or football, a club wants to complain about another organisation in a league, there will usually be a right to complain to an association on specified grounds. And as Laura mentioned, manufacturers of sporting products such as safety equipment will have a contract with the purchaser of its goods. The purpose of a contract is to set out parties' roles, responsibilities, and allocation of risk and liability where it's possible to do so within the framework of common law, statutes, and public policy. It's clear from what we've heard so far this afternoon that there's likely to be a trend towards more claims from participants in sport, particularly players, in both a professional, semi-professional, and non-professional context. Because of that trend, it's important for organisers such as professional and private members clubs, schools, and other sporting organisations to think about how risk is managed and, where possible, mitigated. That risk mitigation will likely come through operational practice and procedure, but also possibly from a contractual perspective. It's helpful to clarify when and how responsibility is actually assumed for injury. As a matter of law, it may well be beyond the control of organisers to disclaim liability, but it might be possible to shape and clarify through statements and agreements what roles and responsibilities organisers and participants agree to take on. If nothing else, the clarification of those roles and responsibilities might drive behaviours around the carrying out of risk assessments and will clarify in the minds of participants what is expected of them. While, as a matter of public policy, it isn't possible to exclude liability for death or personal injury under a contract, and so contractual waivers are not legally enforceable, if a participant's obligations, such as the use of safety equipment or the requirement to undertake medical examinations, have not been fulfilled, that might influence how a court assesses liability in the event of a claim. It might also influence how a claim is handled by insurers. It's nothing new to see sports, such as rugby, having guidelines around how the sport's played. For example, there are guidelines about uncontested scrums, and particularly for younger players, about contests between players of disparate sizes, and why sports such as rugby and racing have strict concussion protocols. There can be no doubt that those who are immediately responsible for the organisation of a sporting event, such as a school hosting a football, rugby or cricket game, will be held to owe a duty of care to participants. And so the standard of care required will be informed by and may include compliance with such standards. For example, there was a case from 2007 in England whereby a school was held liable for injuries caused in a rugby game by a pupil the school had allowed to take part, who was well above the age group for the match and whose superior size and strength had contributed to the claimant's injury. Referees and coaches will also potentially owe a duty of care and so should consider their own roles and responsibilities. On the other hand, how far that duty extends to less structured relationships between clubs or other sporting organisations and competitors and participants depends very much on an analysis of the relationship between all protagonists, the facts of each case, and in particular on the extent to which the club or other sporting organisation has assumed responsibility for safety. For example, there was a case about an employer that organised an activities afternoon at a country park, which included a cycle race. Someone was injured and was not wearing a helmet. Expert evidence indicated that a helmet would have prevented injury. The organiser was held to be negligent because they had not carried out an adequate risk assessment, nor had they taken expert advice. The court refused to accept an argument that the injured party was capable of making his own risk assessment and informed decision as to whether or not to participate in the event. It's also clear that for a successful claim against an organiser, there has to be a duty of care, which is a subject that requires an entire afternoon for discussion. But it's clear that had a risk assessment in that case been carried out and safety equipment been supplied, the risk of injury would have been reduced and any claim arising might have been easier to defend. So if a potentially dangerous event is being hosted, risk needs to be considered. Failure to assess sporting risk, to intervene to minimise risk, gives rise to the potential for litigation against organisers and sporting bodies for negligence in sports management. If children are involved, the risk assessment around the operational aspects of the sport needs to be even more stringent. A clear contractual statement of intent can assist in clarifying where responsibilities lie, at least from an operational and practical perspective. However, we should remember that it isn't possible to delegate rightful responsibility or liability to a third party, contractually or otherwise. Anecdotally, I was speaking not so long ago with a former general manager of a certain football club in Glasgow, and he was telling me that it's no coincidence that players who have been drawn to play for the national side in international games are often whisked back on planes straight after the game, even if it's in the middle of the night. That's because the national side contractually assumes responsibility for the players when abroad, and the policy is to return the players home as soon as possible to discharge responsibility, whatever the time of the day or night. So, in terms of some particular practical matters to consider, as an organiser of sporting events, I think it's important to check a pitch before play to ensure there's no obvious dangers. Players should be removed from play if there's a confirmed or suspected loss of consciousness or concussion, and we saw that in practice during the Six Nations games this past weekend. Injured players should be monitored until deemed fit to leave the venue. An independent doctor should assist team medical staff in a professional context, and grounds, stadia and organisers should have emergency action plans for injuries. So, in summary, I think that the increased risk of litigation is going to bring into sharp focus the risks around sport, the management of that risk from an operational contractual perspective, and how relationships are regulated. And that's it from me.
Thanks, Andy. We've got one question on the Q&A function. Feel free to add any more, and we're happy to pick those up over the next few minutes. The question that's there is, if a group of players played in rugby tours across Europe, how easy would it be for them to bring a court action in Scotland? Have any of you got any thoughts upon that?
Me, I can take that one. Thanks, Craig. So I'm assuming that the questioner has in mind the potential for there to have been wrongs committed in different countries. So the injury has occurred in different countries. Going back to the head injury, they've been knocked on the head, across Europe. So from how easy it would be to bring it in Scotland, it depends. It's probably quite a complex issue. It will raise two issues, I suppose, both jurisdiction and which is where the action can be raised, and also choice of law. So in theory, and that is beyond today's time slot as well to discuss jurisdiction and choice of law. It's quite complicated, but you could bring an action in a group action in Scotland, i.e. you could bring it under the Scottish jurisdiction and get the advantages of the Scottish jurisdiction, i.e. the group proceedings and possibly other aspects of it as well, but you could apply the law of France within the Scottish jurisdiction. And where there's maybe more than one option as to where a claim or claims can be raised, then you would expect that a claimant, their solicitor, would choose the one that's most advantageous to their clients. And so given that Scotland's now got this formal procedure for group proceedings, that might be perceived as one advantage. Another one, when it comes to which law to apply, if there's a choice of law there as well, then the level of potential compensation which a claimant might achieve could be higher in Scotland than elsewhere. So that might make Scotland attractive both in terms of jurisdiction and under the law of the land. In fatal cases in particular, a claim brought under the Scottish law by the family of the deceased will usually attract significantly higher compensation than the equivalent case in England and Wales. There's also a possibility that new rules about costs in personal injury cases in Scotland, some of you might have heard of that, qualified one-way cost shifting. It's something that we've talked about for many years now, but it is on its way into the Scottish courts, and it might be applied to group litigation as well. But if that happens, essentially it means that claimants can raise actions, and even if they're unsuccessful, they won't have to pay the defender's legal costs. So that might be another reason to try to bring an action within Scotland. And if you have been suffered injury within Scotland and elsewhere, but if you can show that it's been caused or materially contributed to in Scotland, or it's where one or more of the defenders are domiciled, where they're based, then you should be okay. One thing I just would quickly point out, and we're out of time, is that there is still an argument for the defenders to say, well, actually, you might be able to bring it in Scotland, you might be able to bring it under Scottish law, but actually it's not the best forum for it. It's the forum non conveniens argument. You can argue that actually the claim might be more appropriately heard in another jurisdiction and under different law. It would depend on the specific facts. But for these types of claims that we're talking about, certainly in the elite sports, I think that jurisdiction and choice of law issues will be aplenty.
Thanks, Laura. We've got a couple more questions. We might be able to just pick off one more. The first question is, some schools still have compulsory contact rugby for some pupils. Does this become hard to defend if a catastrophic injury was to occur?
I mean, I can probably take that one. I think, again, it comes back to duty of care and negligence. Did that injury occur because of negligence? So I mean, that's a bigger question. Should contact sport take place at all within schools? Should it be compulsory? That is a far bigger question than we have time to deal with today. But I think going back to what you would be looking at in a situation of a case involving those injuries, as I say, has there been negligence? Has it occurred because of a scrum collapse, and was there something wrong with the way that the scrum was set up? So I think it is case by case basis for that.
Thanks, Carly. We have a couple more questions, but we'll pick up with those offline. If one of them is anonymous, if they want to give their name, then we can happily pick that up after this session. But thank you very much for joining us today, and I hope you've enjoyed it as much as we have presenting. Thanks a lot.